Well, thank you very much for inviting us, John, to present this, and frankly for being such a great partner in what has been a very interesting exercise in terms of how to make the internet routing more secure. So, in a nutshell, for those of you who don't know what RPKI is, I guess I owe a great thanks to the APNIC presentation immediately before to highlight that this is something that's growing. This is a way that we can actually make routing more secure. As you know, we create routing tables by having BGP partners exchange routes. That information becomes basically unauthenticated. You have to take the word that the person you're sharing routing information with, that they're in fact giving you a valid route. And there are two technologies that can make that more authenticatable. One is BGPsec, which is actually to make sure that the entire step of the route, all of them are validly followed. RPKI is the one of what is a much more modest technology. It's called origin validation, which is you can verify that the last step that the route is pointing to is in fact the authentic location for that website. So there's two steps to RPKI. The address holder has to sign use a public key given by their RIR to sign a certificate, and that places in a certificate authority generally hosted by the RIR. And then the ISPs have to access those libraries to do something called route validation, route origin validation, to actually screen on the basis of that information. And every time they get a route, they should double check it against the certificate authority and say, they think that upenn.edu is located here, according to the route being advertised by my BGP partner. You can then look it up in the library and in the certificate authority, the certificate library, and make sure, in fact, that is pointing at the right address. And that will make the internet considerably more secure. Not a complete solution, although with edge providers building closer and closer to the customers, if it is a one-hop route, it actually can be a complete solution. But what we see is a growing interest in, on the other hand, it's fairly easy to do and would make routes, it would guard against certainly misconfigurations, but in fact would provide some degree of protection against route hijacks. There's been a bunch of things in the news lately, some very conspicuous hijacks of Cloudflare's DNS and Amazon's DNS. As Cloudflare has begun committing to RPKI, beginning to filter on this basis, and is developing their own validator software. Interestingly though, if they deny the route, it'll simply migrate through transit some other way. The biggest news are people like AT&T who are starting to actually filter routes based on RPKI information. Google is starting to do the same. They're in fact flagging routes. They've announced that later this year they will begin filtering actively on it. And what we see is, interestingly, NTT is doing something else, which is they're combining using the certificate library to clean up their IRRs, to actually look at how they're configured, combining it with other information to improve the routing quality information. We hear from APNIC that they're in the process of pushing RPKI, and David Wishnick, who's my colleague at Penn, just showed me a posting from the NANOG list yesterday that 3 African ISPs began filtering on the basis of RPKI on April 1. So this is a technology that's increasingly growing in importance, and one of the things we'll talk about more, I think, when John talks, operationally this has some implications for you if you want to make sure that your networks flow smoothly and all of this works properly. That's really the domain of technical experts like yourself. We were actually approached by the National Science Foundation to solve a particular problem, which is generally RPKI, like many technologies, have been deploying relatively slowly. But the big mystery is it's been actually deploying much more slowly in the ARIN region than it has in other regions. RIPE has now hit 43% of its addresses have signed certificates. And you see in the LACNIC region is roughly 23%. ARIN is at 4.5%, and most interestingly, the others are growing slowly. ARIN region has been roughly flat across this time period in ways that create some concerns. The question is, what is it? Is there something about what's going on in the ARIN region that is that's preventing it from being more widely deployed? That's who's signing. If you look at ISPs, how many are filtering, there is an APNIC resource that is actually looking at ISPs and how many of them are filtering. Again, the number of ISPs in the RIPE region is significantly larger. And in fact, among those who are deploying route origin validation, 80% of them do not include the information from the ARIN region, including the ARIN TAL. And so we were asked by the National Science Foundation to do a study to investigate whether there are legal barriers that are at play in ARIN that did not exist in other areas. And in fact, this is on the basis of several conversations that people have had at different conferences. And in fact, they focused on certain clauses within the contracts that ARIN asks different users to sign. As you know, most ARIN members are resource holders, so you've signed an RSA to have the address. There's also something called the Relying Party Agreement, which other people who build on information provided, who are not themselves address holders but are building on the information, need to sign. Our methodologies, we've done analysis of the contracts on a comparative basis with both ARINs and in other regions. We've done a broad scale of interviews with other stakeholders and have engaged very actively and very cooperatively with ARIN, and I think that it's been a very positive dynamic and one that I deeply appreciate. We've been at the last 3 NANOGs. We released a report at the end of the year, which we are happy to share with you. I apologize in advance. It's a lawyer-length report. It's about 30 pages, as opposed to a technical-length report. But it's one of the things that's appropriate for the subject matter. And to me, I really welcome the opportunity to engage the ARIN community, because this is something of vital importance to the ARIN and all of its members. And this is the first opportunity we've had to talk about this here today. Okay. So if we were going to think about the key issues involved in this study, we're looking at the Relying Party Agreement, particularly the fact that the 4 other regions do not, in fact, require a Relying Party Agreement, and there's certain clauses within it also that we're analyzing about the indemnification clause, about allocation of liability. There's talking about how we're going to style the acceptances, and this is an area where ARIN has already made changes to its policies in response to what we've learned through the study. And a possibility of another way to managing liability is and this is a topic which is just now beginning, and we'd love to get the feedback from the community, is whether we should separate the RPKI function from the numbering functions provided by ARIN and create another entity to handle that. There's another provision in the RPA called the Prohibited Conduct Clause, which will explain that causes some problems. There are other vectors for possible diffusion beyond law involving procurement policies. We're going to talk about best practices, because part of this is about implementation, not just liability, and that's where this is going to affect everyone in this room. And there's a series of other smaller recommendations which are mentioned in the report, which I'll just flag for you. So starting at the beginning, so as of now, the primarily most widely used validator software, this is the thing that ISPs run that accesses the library and determines which routes are valid and invalid. To get to the library, you need to access something called the Trust Anchor Locator, or the TAL, which tells you where the library is located for each of the 5 RIRs. As of right now, the leading validator software is shipped with 4 TALs preloaded, but not ARINs. And this is one of the primary reasons that 80% of the people who are validating routes do not have ARIN's TAL. And so what's interesting is the reason that it's not distributed is by policy, ARIN requires that everyone who wants to access the TAL go to ARIN's website and click through to get access. And the reason that is there's an aspect of US law that makes it much stronger to say that by clicking through, you create a contractual acceptance of the terms and conditions of the access to the ARIN TAL. And because that is a different step that is not required by other RIRs, it makes it more complicated, or at least the validator software distributors to believe that they cannot distribute their software with the TAL preloaded. What's interesting is, why is that? There are aspects of American law about why we'd want to handle this through a contract as opposed to through general principles of law of negligence liability. But it's interesting, as a matter of contract formation, the contract is much more likely to be found valid if someone actively clicks on something. There is precedent that if you put terms and conditions nearby, or if the person is aware of it, US courts have found people bound by those terms, but that's not entirely clear, and it does create some risk. And there is a much stronger authority that says if the terms and conditions are in the visual field of the person who is accessing the resource at the time they accept the resource, then it's more likely to be found to be a binding contract. So we actually analyzed all the alternatives. There are people in the community who would like to abolish the RPA altogether. I suppose another option is to keep the RPA unchanged. And a third option is to keep the RPA but to make some modifications, and particularly the primary focus we'll initially focus on is the indemnification clause, which requires whoever's accessing the resource, if any legal problems happen or if any liability happens, they have to cover any liability or money that ARIN has to pay as damages. So in terms of dropping the RPA, this is a serious proposal pushed by a number of people in the community. It has some advantages. If you have no contract at all, it would promote the widest possible distribution of the towel because it becomes very easy to preload it in all the software. It has some downsides. As we said a minute ago, it does create uncertainty as to whether the contractual terms will be binding. In the absence of contractual terms, you go to general principles of negligence under US law, which are quite uncertain. It's hard they work functionally pretty well, but there is some overhanging risk and uncertainty that exists that is greater than under contract law. The nice thing that we usually handle these things is through some sort of warranties in the contract. You represent what the product does, and you can actually allocate risk explicitly instead of after the fact by a court. And this does take into effect that the US environment is much more litigious than the other environments, and that partly explains the differences in policy. The other alternative I'll talk about briefly is it is conceivable that ARIN could keep the existing RPA unchanged with blanket indemnification. Our analysis suggests that that would be inappropriate because if you as a relying party are enforced to indemnify ARIN against any liability, any problems that come up, that could include indemnifying them against problems that fell within ARIN's responsibility. And a general principle here is everyone should be responsible for the things they control. You should not be held responsible for things that are outside of your control. And to ARIN's credit, I think in our conversations with them, they've recognized that they probably need to they're open to rethinking this provision, and that's part of their active discussions to try to find out exactly how that provision and that liability should be reallocated. And there's where the devil in the details come. When we start to change that, finding that proper allocation becomes much more difficult. So the other alternative is to keep the RPA, but instead of an indemnification where the relying parties agree to compensate ARIN for its risks, for its liability. The way we handle it in many areas of software is you sell the software as is, like you sell a used car, no warranties, you make no representations, everyone understands they take it on their own risk. This is how we do open source, it's how we do a large number of software distributions of different kinds. And in fact, we did this partly by comparing it to the policies of the other RIRs in addition to other types of software and to see how it's fared under those regimes. And the other possibility that we've talked about in the community is if you download the validator software from RIPE, who's the primary provider of this now, although there is another one by Dragon Software that's not really properly supported at this time. It's interesting. Generally, you're going to have to click through some form of acceptance of that software. You can also configure that so that you're accepting the ARIN TAL contract at the same time. And this is a functionality which ARIN has already agreed to change its policies to support, and I think to much to the credit of the organization and how this discourse has gone. But that would allow them to get the acceptance of the contract done. The question is, what are the terms of the contract are you accepting, and can we shift from an indemnification clause to an as-is disclaimer of warranties? So we did an analysis comparing ARIN's policies to the other RIRs. ARIN does include a disclaimer of warranties, but they also include a provision requiring relying parties to indemnify it against any losses, but also giving them a duty to defend and hold harmless, which means that they have to pay for the lawyers and the relying party have to litigate through it. And it also applies to actions taken by not only the relying party, but downstream users of the relying party who are actually not part of this contract. I understand the reasons why this was put in, but if you compare it to the others, APNIC, if you look at all the others, they have no explicit agreement. If you look at AFRINIC and LACNIC at the back, they actually have no relevant terms and conditions whatsoever. RIPE NCC has a disclaimer of warranties, but no mention of any indemnification or hold harmless or duty to defend. And APNIC has no agreement, but their term indemnifications do mention indemnification, but do not talk about a duty to defend or hold harmless. So ARIN does have policies or contractual terms here that differ somewhat from the existing RIRs, and they differ in the fact that they have an RPA. And so this led us to really seriously consider the approach taken in RIPE, where they're actually seeing broader scale distribution of whether a disclaimer of warranties would be sufficient to protect ARIN from liability in much the same way ARIN seeks to do based on this indemnification clause. So as-is disclaimers, as we know, are widely used. It would, I think, would be a fairly good defense against liability for ARIN, because you do have, if you sell something as is, you can't go back and go after them to say, well, it didn't function properly. There's an interesting question, though. There is some, what I would think, procedural risk. There are ways to get rid of cases very, very early in the proceedings. There's sometimes you can get them later, but before trial, and sometimes you have to go all the way to trial. An as-is disclaimer would probably require ARIN to go through at least to the middle step of litigation, most likely, instead of getting rid of things at the very beginning, which does create not so much overall liability risk, but some litigation costs inherent in shifting from a disclaimer, from an indemnification clause to an as-is disclaimer of warranties. There is an interesting thing that we studied, which is to try to see, has there been litigation against RIPE under its as-is disclaimer? Has there been litigation under other forms of security based on that are governed by as-is disclaimers? And the answer is there really are no cases. And this is sort of a wonderful Rorschach test that you can make of this as you will. Some people would say that the risks are, this tells you the risks are low. Other people will say the risks are unquantifiable because we don't actually have evidence of how these would come out. I think that deciding things in the face of uncertainty is something that the community is going to have to directly confront in thinking about how the benefits of deploying simplifying the deployment of RPKI against this data we have here, which shows that the risk is going to be hard to quantify and to try to understand. And the question is what the significance of the lack of cases really is. I will note that the RSA does include an indemnification clause, and as there's always the caveat that past performance does not predict future results, in the sense that this is information, it's the best information we have about the future, but there's always possibilities that things are going to vary. There is another radical solution to limiting ARIN's liability here, which would be to stand up a new company or a new organization that would hold the RPKI certificates and be responsible for maintaining the library. There is a debate about whether this would be just for the ARIN region. It could possibly include other RIRs or other NICs that are doing this sort of registration. And there are precedents of standing up organizations of this type in the past. There is a number of pros. In fact, it would make it more acceptable for this organization to take on risks and be able to carry it on for the community. And in fact, they would be entirely focused on RPKI implementation and deployment as opposed to the many responsibilities that ARIN bears. There is some history here against setting up certainly a worldwide organization. I always think that there's nothing more revolting than to say we had that fight 20 years ago, and it's a very different world as we all know now. That's a conversation I think is worth having again. But the more serious question is standing up an organization would require membership. It would require a certain amount of support. It would require organizational support beyond financial. You would have to have a board, have to have some governance. I always envisioned this would be organized satellite to meetings like ARIN in the beginning, but at some point it would have to have its own way to figure out what its destiny would be. There are actually other ways to facilitate risk management. The first I mentioned about making people click through when they load the validator software into accepting the ARIN TAL. There's another thing that we're discussing, which is individual contracts don't need to be signed for every individual instance you're actually setting up. And one of the things that the concern we got from some of the open source community is they want to be able to just deploy instances automatically. As it turns out, you do not need a contract every time you put a new build in. If it's an enterprise as a whole has agreed to it, basically on a if you think about it as a site license basis, you do not need individual acceptances. And we're thinking about ways to facilitate that sort of agreement to make that work. And in fact, there's some things that the RPA could include inside, such as limiting to making sure that liability does not include what we call consequential damages. So if your phone call fails and you're paying whatever $50 a month for service, okay, the worst you're out, I'll pay you back the $50 I didn't give you the service. You're not liable for the deal that fell through because the phone call fell, typically in the telecom space. Those are called consequential damages. They're almost never honored. Putting that explicitly in the contract would be an effective way to shed liability. But our hope is really to stimulate a much broader conversation in the ARIN and the larger RIR community about the right way to handle this and the right way to manage risk. Because I think there are more than one reasonable option. You'll see in the report, a belief lean towards one particular set of options, but it's something that we're open to considering all possibilities. There are some other minor points, or not minor points, but other aspects. One is ARIN's RPA continues something called the Prohibited Conduct Clause. It forbids the sharing of RPKI information or information derived from RPKI in a machine-readable format. Anyone who's deployed security knows that looking at other organizations, three other RIRs have no provision. RIPE prohibits marketing, advertising, the use of this for those types of purposes. What we've learned is that you need reporting and research anytime you look at new security, and that's best done in a machine-readable format. And ARIN has already agreed to waive that for non-real-time, non-operational uses. What we're seeing now is people are wanting to integrate this with IRR data for real-time operational uses. In fact, no set of information is perfect, and taking multiple sources of information of different provenance, no matter how hard you try, actually would probably make routing better. We would like to facilitate that kind of combination in real-time data, but to do that would require some adjustment to the Prohibited Conduct Clause. There is another way that you can try to get RPA adopted more broadly. What we're discovering is the primary obstacle is many operators just aren't demanding this. And until it does, the customers aren't demanding it. Until that happens, the operators are less inclined to deploy it. If security is important to a customer, they can begin including it in their calls for proposals. They can do it into their contractual terms as a requirement. And think about this as a partnership. We want to work with people who are committed to making the security environment safer. This is not just governments. It can be any private company as well. And in fact, I think that it solves the chicken and egg problems. And in fact, it fits nicely with an initiative being led by ISOC called Manners, the Mutually Agreed Norms for Routing Security, which includes filtering and refers to RPKI specifically as something that partners should do, and this currently has 144 participants. The other thing that we've learned through the process, very much in dialogue with John, is that it is important to understand this isn't just a legal matter, that in fact this is an operational matter that every operator that deploys RPKI has to take into account. No RPKI cache, nothing even at 5 nines, 6 nines reliability, there's always going to be a possibility of some downtime, and we've seen outages, admittedly brief, in RIPE, in ARIN, and most recently in AFRINIC, and they are going to happen. And like any environment you're in, you need to plan for that and figure out how you're going to fail over. And there are best practices that make it important to say that if the cache becomes unavailable, you have to fail open, not closed. Because if you fail closed, you will disconnect part of the internet. And so there are things outages that can happen from misconfigurations on the operator side if they don't adopt best practices. There are RFCs that give that guidance. There are people who can provide that information. And in fact, that's the obligation on the operator side. The RIRs are going to have to take on some additional responsibility, providing clear information about refresh cycles, updates, uptimes, response times, all the things that you need to know to operate, how to work with an organization or a new service. And in fact, we really think there needs to be a dialogue here. And in fact, this is going to put obligations on ARIN to support things beyond what they did before. Those other two small issues we talked about, there is some reports that, government agencies are unable to sign documents that include indemnification clauses and choice of law clauses. ARIN has already indicated its willingness that if there is a legal requirement that the government agency cannot do that, they will waive those. And that, in fact, is, I think, a helpful reform that's already been implemented and I think is an example of ARIN's cooperation. There is a recommendation some legacy address holders are unwilling to sign the get the services they had before when they were legacy holders without signing an LRSA. But if they want additional services, they have to sign. RPKI is an additional service. And so, in fact, their objections are to other aspects of the LRSA, not the RPKI aspects. RIPE has created something called a non-member services agreement that decouples these two issues because the broader issues of the LRSA are independent of RPKI. We've suggested to ARIN that they at least consider that, although I will say that I don't believe that is a complete solution. First, the problem is vanishing as more and more legacy holders look to sell some addresses. They do sign the LRSA. But the other real marker to me is all resource holders signed an RSA to get their IPv6 addresses. We do not see broad-scale RPKI distributed deployment in IPv6 either. And so what strikes me is that even if you solve this problem, it ultimately would not be a complete solution to the RPKI deployment problems. So potential next steps, ARIN should consider RPA changes that we've discussed here about the liability provisions and the prohibited conduct clause. This community needs to start a discussion about its interest in supporting a new nonprofit to hold the certificate libraries. There is a lot of education, both on the network operator side and the RIR side, about best practices and how to deploy this properly. But in fact, this is and the last thing is I think this is a change that is coming. Increasingly significant partners are getting involved. I think that it is, I've been around for a few years, but it is time for this community to start engaging with the reality that many of the major partners you deal with are going to start filtering and expecting their partners to be deploying RPKI. Thank you.
So at this time, I'm going to ask Chris, you can either stand or seat, whatever you want. I'm going to give ARIN's presentation, and that because it might answer some of the questions and save us time, and then we'll take questions jointly at the end. Here, wherever he wants. Okay, so RPKI service risk analysis. This is an ongoing document. As we learn more, we update it, but I want to give a high-level overview. I have to talk about what's the risk we're managing, because to some extent, when we talk about the legal terminologies, it's all about making sure the right thing happens when the wrong thing happens. And so we have to talk about what's the worst case. What could happen if ARIN services are unavailable? How do we protect the organization from being held by, inappropriately being held for damages that aren't necessarily our cause? And so I'm going to talk about that, including the potential for inadvertent service providers creating dependency on our service. And I'm going to talk about the ongoing analysis framework we're using for looking at the risks. This is based on the board direction to me after looking at the UPenn report and talking about what we need to explore, legal, contractual options, operational options, to try to figure out, can we evolve to something that addresses some of these concerns without creating undue exposure. And then I'll talk about where we could potentially come out at the end. So I think Chris covered a lot of this. I'm not going to go through it in detail, but RPKI allows a second, it's a second service, an optional service, that allows resource holders to declare which networks can actually announce routes for them. And this is done through ROAs published by those who are address holders, and the act of listening to those ROAs is route validation, ROV. And the fact is that the way it's set up is that when you're doing route validation, if you lose access to this information, it shouldn't be a problem. You should fall back to the routing that you're doing today without route validation. That's the theory. And that's actually specified in the IETF operational guidelines for RPKI. RPKI protects customers with published ROAs from having people inject routes that don't match the listed information, and it shouldn't provide any impact. If that service is unavailable, well, then you're not protected from route hijacking, but the loss of the service shouldn't impact your network. You should be exactly where you are today. We call the people who rely on our information to do route validation relying parties, terminology in PKI. And we actually provide the information in our repository encrypted, as everyone else does. You access it via an encryption key called a TAL, a Trust Anchor Locator. And we found an interesting problem, which is what Chris was talking about earlier. in order to make sure that we had an agreement with the people using this data, we have to be able to show that they're aware that there are terms and conditions. We originally started out with something very onerous. You typed in your email and you clicked I accept the terms, and we mail you a link, and then you take that link and click on it. We evolved over time to the acceptance on a web page where you click on it and you download the towel that lets you get access to this information. Now we just say download the towel. After a lot of analysis legally, we've gone through 3 iterations, and we're at the point now where all you need to do is, when you're installing your software, go out, take ARIN's towel, all the packages direct you to the page. It says, here's ARIN's Trust Anchor Locator, which will give you access to its repository. Download it. And we say on the page, prominently in the line of sight, if you download this, you're agreeing to our relying party agreement. That's unique to ARIN. The other 4 RIRs actually provide you access to their repository without you consciously doing anything. As was highlighted in the earlier presentation, U.S. law is pretty clear. You don't get bound to agreements that you don't have some way of knowing that you're entering into. So we have to do it differently if indeed we want an agreement. And that turns out to be an issue. Some people object because it's an extra step. Literally, you can't take the software and say, launch, build, done. I actually have to go get this document and do that conscious acceptance. Reality is that the act of actually safely paying attention to this information and inserting it into your route determination in your network is a technical task, and it's not trivial. It's going to take people work. It's going to take people hours of planning and work to do correctly if they don't want to get shot in the foot. And so to that extent, even if it's only an hour, the act of getting one file is not a technical hurdle. It is a hurdle to automation because, again, inherently, automated software installation is incompatible with your knowing acceptance unless you're aware that running the whole package makes you bound to terms and conditions. So we have a pretty hard conflict here. If we want to have an agreement, then we pretty much have to have a way for someone to consciously get the towel. And that's a pretty hard situation. Note that the reason we need an agreement, the reason when we rolled out our services, we said, yes, we will have a relying party agreement. Not to say that we're unique in that. Other RIRs put terms and conditions on the relying parties. You just don't see them. You've already agreed to them because you're using their RPKI data. They're just not in the United States. So they put it on their website, and you're, in theory, bound to it depending on that law and jurisdiction. So, for example, RIPE has terms and conditions that limit the damages you can claim against RIPE. That's what we were worried about with ARIN, but again, the different legal regime says we need a more clear contract acceptance. The concern we have is that RPKI is complicated. And we already have people out there using RPKI to announce ROAs for their network. They're announcing information about which ASs are acceptable based on their network prefixes. And we already have misconfiguration. You can go out there and look and see the number of announcements which are invalid because RPKI has some interesting length issues with match. RPKI has some other issues in terms of complexity of setup. And so we have people using this information on the publishing side who already are making configuration problems. We don't know if someone on the relying side is going to fail open, as was discussed. If our service goes unavailable, we honestly don't know if every network will fall back to pre-RPKI routing. That's what they should do. But even if a small percentage of them don't, we're going to be in a world of hurt. So let's talk about the world where we're successful with RPKI, okay? If we're in a situation where we have global RPKI adoption, 30 to 50,000 networks are looking at our information and validating routes. Based on the error rate of configuration we see on the publication side, based on the error rate we see in other issues, like when they did the DNS key rollover, the first time they went and looked at who didn't have the new key, numbers like 2% are quite reasonable. 2% of 50,000 providers is a big number. we could have hundreds of service providers who fail to do appropriate validation when we fail. Now, again, IETF says best practice, you should, if you can't validate the RPKI information, you can't get to the repository, you should go to not found, and that shouldn't be a problem. But again, even if 2% people misconfigure that and drop those routes, that means that you could have 100, 500 providers who lose North America because ARIN's RPKI-CA is off the air. Now, there is some issues, which is that if our RPKI-CA goes off the air, it doesn't happen immediately. People have cached this. There's timers that apply. They're going to go back and refresh. It's only when they go back and they're getting to the expiration that they really have to be able to reach us. So even if we're off the air for whatever reason, and even though service providers should fall back appropriately, it's not a knife edge. It's not like the 200 or 300 misconfiguring providers, when RPKI is fully deployed, they're the ones that are suddenly going to disappear. They're going to disappear a few every hour for the next few days until we get our service back online. Now, you'd say, well, good answer, John. Don't get your RPKI service offline. Just have one that runs reliably. We all try to do that. But so far, RIPE's had an outage, we've had an outage, and I can say this week, Afrinic's had an outage. So you have to expect the fact that this is going to happen. What we don't want to do is we don't want to add a service to ARIN that makes the internet more secure, but actually creates fragility for ARIN, the organization, and endangers the registry as a whole. Now that shouldn't happen, but we're not in other legal regimes. We're in the United States. There's a bit of litigation in the United States. People like to sue. And so the issues we face are somewhat different, because if we have an outage and there's several hundred providers, because RPKI is being paid attention by 40,000 providers, and there's a couple of hundred that can't get to North America, yes, we will face the question of why we went down and what is the consequences of that. Now again, every one of these parties, every one of them has made a mistake. They shouldn't have a dependency on our RPKI data. They should not. They absolutely should not. They have what we call unclean hands. They don't have the right to complain about our service being down because it shouldn't matter to them. But I would have to talk to a jury about the technical responsibilities of the people trying to sue and talk to them about how their routing configuration wasn't right. Now you understand now, I got 12 random people off the street, which I'm now talking about route weighting to, and RPKI states of, invalid and found and not found, it's going to be a great time, okay? And if I have to do that a couple of hundred times, I'm going to have a great adventure. So what we do is we have a contract that provides for indemnification. When someone comes to us and says, we're going to litigate with you because you were down, we go, you're not, because you actually agreed to cover the expenses, the liabilities associated with your use of our service. If you suffered damages or someone else suffered damages because of your usage, you're the one responsible. We put the responsibility on the people using the service because it really is their responsibility. All the legal agreements do is say that. Okay, so this is what we're dealing with, is that we could have a very significant issue if we go down when RPKI is well deployed worldwide. And despite the fact that it's not our issue because there shouldn't be a dependency, it could be a very significant event for ARIN financially. It could actually endanger the entire organization. We do what we can with the agreements to prevent us from being inappropriately held by someone misusing and misconfiguring this data. Now, here's the issue. We have to look carefully at how we can mitigate this, and our past solution works great. Actually, it's wonderful. We have a relying party agreement, which we know we can say anyone using the data has agreed to because they couldn't have gotten our TAL. You're not allowed to redistribute our TAL or embed it in software. So everyone who's using our data, I know, has agreed to the RPKI relying party agreement, and every one of them has indemnified us, and we sleep well at night at ARIN. Okay, we sleep well at night, but as Christopher's report says, it could be impacting RPKI deployment. So what are we doing? We're looking at all the options for mitigation to see, can we put together a tapestry of solutions that would allow us to relax our approach. The board's directed myself and our general counsel, Steve Ryan, to do this. We started this process. The report came out at the end of last year. We started this process after meeting with the board in January. It's going to be an ongoing thing. It took a year to put the report together. It's probably going to take us a similar amount of time to run down all these ends. We have made some incremental improvements on the way. I want to talk about some of the risk strategies we're looking at. So one of them is that all of our ARIN customers actually don't need, per se, a separate RPA. They're bound, a separate acceptance, because they've bound to the RPA because it's the service agreement terms and conditions. When you say you use an ARIN service, if you already have an RSA with us, then by reference, the terms of that service you've agreed to, including indemnification. So everybody in North America who's a customer with an RSA, the 6,000 members and then another 15,000 end users who have an RSA or LRSA, they're already bound by this agreement, even if they don't take an explicit step. And that actually means the parties who might be misusing the data and wanting to litigate, we don't have to worry about that center spot. And that removes some of the parties that we might have to look at if we're going to relax our measures. Luckily, what we do for relaxing our measures doesn't actually change our status with respect to the big part of North America. And that's good, because many of the people who want to litigate us are people in North America and may have redress space. And so even if we change the RPA or change how we do the agreement, these folks already have an agreement indemnifying ARIN for the services we provide. It's possible we can rely on the RSA and its terms, and that gives us some leeway, because if you think about it as a donut, the North American hole in the middle has been carved out. If you're an address holder, you're probably not someone who can successfully litigate because of the RSA that you already have. So that we need to consider further. That allows us a little wiggle room, but it doesn't handle multinational companies that have address space elsewhere. It doesn't have large organizations internationally that don't have number resources from ARIN. It's not a silver bullet, but it does reduce the number of parties that we have to think about. Relying parties, as we said, the situation we face presently is that the risk mitigations require that we look and try to have a balance in the relying party agreement. Right now we have a very complete relying party agreement that includes limitations of damages and disclaimers and indemnification. It may be that's overly robust. There are some folks who have looked and said, I can live with this, except I don't like indemnification. It's interesting, some of those people have signed an RSA that contains indemnification, so I have to scratch my head and go, well, you already did that, but that's okay. Let's take it on good faith. Some people have a problem with an indemnification clause who may be able to move forward if we took that out of the RPA. So some of the things we're looking at, okay? We're almost certainly going to strengthen and make sure our existing RSA terms handle the ARIN region relying parties who have resources. It's possible we can look at something like insurance. It is possible to get insurance, particularly in a case where you go and explain this is insurance to handle the case of the litigation expenses. Now, there's two problems with this, and I just want to be very blunt. We actually have insurance now to cover some of this. And when you try to get insurance, you have to explain in detail the scenario you're insuring against. This same relying party and route filtering and someone misusing the data, which means you have to find an insurance agent an underwriter who is actually capable of understanding this. I actually have better luck with the 12 jurors, by the way, because random people off the street might be better than those insurance people. And I'm really sorry about that. I'm sorry if you're in that field. No, we have actually done a lot of insurance work. We actually have reviewed our policies. A few years ago, we did an extensive review. We actually know how to use our policies. We've made claims and realized that even when insurers say, okay, you are covered, they say you are covered we think right now, from what we can tell, but here's 3 pages of why you might not be covered if we learn more later. So insurance isn't a silver bullet, because even when they say, yes, we'll cover you, we'll cover you with all these exceptions. So we're going to look at that. May not go a lot of places. Operational failure testing. The best way to make sure no one has a dependency that's inappropriately configured, improperly configured on the ARIN repository is to take the repository down every now and then. And the people who are impacted will go, well, what did you do? We're like, oh, we took it down. So you shouldn't have an impact. If you had an impact, you did something wrong. We can minimize the risk associated with our repository being down by proactively taking it down and letting people correct the problems. And this actually makes RPKI more reliable, because it means when it's up, everyone's appropriately configured. You don't have people who have these misconfigurations. Downside, you announce a date where you're going to take down RPKI repository, you might as well send it to certain hacker mailing lists and say, hey, we're leaving the internet unprotected for these 4 hours Sunday. Do your route hijacks in this window. So you may not be able to take it down in a way that you announce in advance. And then if you don't do it in advance, how do you do justice to your customers? Because you're like, oh, we want to take it down, but I can't give you warning, because if I do, I'm warning the bad guys that you're exposed. Some fuzziness we have to work out on that. And then, of course, the other suggestion, separate RPKI services affiliate. I'm not going to go through these in more detail, because we'd be here all day, but as I said, we're going to rely on the RSA for our ARIN religion parties, make sure legally that's all ticked and tied. We're going to look at the insurance issue, but it's complicated. We're going to look at operational failure testing. We're going to look at our timers. We have timers in our repository, and we have timers in our underlying PKI infrastructure. We need to look at those, see what they are, see what makes sense. So, possible outcomes. Let's talk about some of them. One of the other outcomes we're being asked to look at is reduced indemnification clause. We'll look at that. Indemnification allows you to very early the possibility of saying the party trying to litigate ARIN and hurt ARIN for its harm isn't an appropriate party. They don't have standing because they have indemnified us. And you can do that early in this legal process, if I understand it correctly. So the good news there is that allows you to preemptively do something. Without that, you could end up going through a lengthy trial, even if you're, as I said, even if it's not our fault, it's their fault, just to get to the end to be able to show that your contract and your damage limitations apply. So we like indemnification because it provides a very clear first opportunity to take someone who's litigating against us based on their misuse of the data and remove it. Giving it up definitely will cause increased costs if we ever have to defend one of these. On the other hand, it's a trade-off. It's the type of trade-off that I have to look at, council has to look at, we have to come to a recommendation, give it to the board, and the board ultimately has to make a call. What's best for you, because you elected them for that. It's one of those heavy board decision matters where the weighty work of the board is making decisions like this. A revised RPA. We're going to look at some other aspects of the RPA. As I said, looking at disclaimer and limitation of liability. If we have an RPA, we really need to have some sort of protection. So we might be able to look at indemnification. I don't know if that's going to work out. But we would still end up with some disclaimers and limitations in there because we have to. We don't want to endanger the organization. We've been told to provide access without any RPA. I'm not sure this is responsible. It increases our legal risk materially. We are going to look at it. We're going to actually formally advise the board as what it comes out to. But for people who say, we're going to get rid of an RPA, or we're going to have an RPA that you don't have to accept, which is the same thing, effectively, very hard for us to prove an RPA you never saw as binding. Yep, it's almost the same thing if we have an RPA that you don't accept. So from that regard, if we don't have you consciously accept it or we have none at all, we're in a big opening, and I'm not sure we can do anything. We might be able to look at the language in it. It's possible, looking at the full balance, insurance, and relying on the RSA for the people in this region, we might be able to look at this, but it's going to be a very difficult call in terms of risk management. So that's where we are, looking at the full suite and the response. Chris is here. You can stand there. Questions. We got to allow a couple of minutes for questions. We are over time, but this is a very important topic, so let's get it out now. Yeah, but the two staff. Go ahead. Yes, front center.
Hi, Chris Woodfield, Salesforce, ARIN AC, and most importantly, not a lawyer.
Yep.
I can right now download CentOS, Debian, any number of free operating systems and install them. Somewhere in that distribution, there is a copy of the GPL. Mm-hmm. On the download page, there might be a link to the GPL. Mm-hmm. At no point am I required to read and acknowledge the GPL or whatever licenses. I can think of a number of other examples. Sure. I can download web browsers and run them without having to click through a license agreement. ISC bind has a list of root server IPs that I'm not acknowledged to disclaim any liability if one of those gets changed to the address of a malware server.
Sure.
I'm really curious what is unique about the TAL that other examples of these types of freely available software information.
Let's break this down because it's pretty simple. So you're talking about software usage, GPL. You get software, you use it. Software license are well recognized. Our repository is not software, okay? Our repository is an information service. And so from that respect, when you go and get those software packages and install them, you're using the software under the license terms, and that's well accepted. If you're using services like a DNS root zone, okay, or you're using a certificate for SSL certificate, if you're using those services, it's up to those organizations to decide what terms they offer their services to you, as is, with no agreement, with an agreement. So you have to ask them why that's a reasonable risk strategy. Okay? It's not that we're unique, it's that we're actually thorough, and we're looking at managing ARIN's risk. I don't know, you'd have to ask ICANN what they have as risk management. Some of these organizations are unique and colorful and may have very interesting strategies for how they manage the risk, but it's really a question not of what's different in this regard, it's go ask them why that's not necessary.
Right, and that's exactly my suggestion, is that this appears to be a problem that other organizations have dealt with some way or another. Is it possible to accept those lessons? I mean, I'm talking about software, but a lot of these software have services behind them. Right. I download Google Chrome. I'm going to be hitting a CRL list. Is there no liability if Google puts a the high
level answer to your question is, for the unique case, like the DNS root zone, it's a historical artifact. And there's actually contracts that involve parties that, like the US government involved in publication, that they may have a solution, but it's a solution that would not necessarily be reproducible. It may be, by the way, when we talk about a separate entity, that might be a way to reproduce some of the solutions used there. In the case of things like SSL certs, well, the question is, you've got a lot of SSL cert providers. If one goes down, it's not the end of the internet. Loss of an RIR for an entire area, North America is a very large coverage area. So, whether or not a particular SSL provider goes out of business, and we've had that happen, is up to each SSL provider's decision. But for the unique one, like the root zone, it's not that we haven't talked to them, it's that you have to recognize it's so unique, we'd have to reproduce it probably by the separate affiliate option. Okay?
All right, thanks.
Chris, you want to comment?
To give you the lawyer's answer, software is different. It's protected by copyright. Copyright creates rights that are good against the world, even if no one signs anything. Why don't we ask ICANN how they do it? We did, and it's in the report. Where both me and David Wishnick, who's here at the front, happy to talk about the details of that. But our general take is their solution probably doesn't provide a solution path for ARIN.
Next microphone. Go ahead. Sorry, Joe.
Also not a lawyer.
Yep.
Joe Provo, Google, ARIN AC, legacy resource holder, random cantankerous hijack hunter. Just speaking for myself. I just wish to urge continued pursuit of angles to allow us to drop the RPA. I don't think a new org would necessarily be the right thing because the T and the TAL is for trust, and I'm not sure how we reestablish that in a brand new stood up thing, in addition to all the other issues you identified. With my service provider hat on, I like RPKI for provisioning, not even just the ongoing route validation, but preventing the LOA-based hijack is a good thing.
Right.
And in the BYOIP cloud universe, it's going to be we're going to see it come back in force. And we are already seeing policies in this sphere being proposed to bleed resources away because of the lack of TAL adoption. I understand ARIN wishes to continue to exist and to service its customers, but if all the customers go away, what happens?
Valid point.
And I understand we have really good lawyers, so hopefully we wouldn't ever actually go to trial, that we'd actually prevent that situation.
Understood. Thank you. Front microphone.
Michael Casadval, Noralo. I am also not a lawyer. So I want to bring a couple of multiple points. Huh?
Go on.
Oh, okay. Multiple points. You may actually have the inverse situations by making access to the TAL difficult. ARIN may actually become liable for creating security issues because by having part of the RIR infrastructure not there, you're knowingly creating a situation where security is being weakened for BGP, and that in itself could be cause for liability. So in an attempt to protect yourself from liability, you may actually be creating liability. Furthermore, I see the TAL much very similar to the way root stores operate, where Firefox, Microsoft, and other browser vendors collect root certificates and distribute them. And them in themselves are not liable for how the SSL certificates are signed from those various root stores. I mean, essentially, you could see the 5 RIRs as a root certificate and then boil down from there. While the situation is different, with the chain of trust, I would say that the TAL itself is essentially a public key, and I'm not completely convinced that there is a liability issue here. Now, lawyers may say otherwise, but the final issue is that if we're going to live in a world where the RPKI servers are not 100% reliable and soft failure has to be the default, we're not doing any better than SSL, where revocation is a wonderful word we talk about and doesn't actually work in practice because of the soft failure mechanism. So are we essentially building a lame duck here that if we cannot trust that RPKI is going to work, and we're going to soft fail if validation fails, are we actually buying security, or are we buying a feel-good thing? That's what I want to boil down to.
That last one is probably a question for the IETF, since they're the ones who give it as their best practices for deployment.
Okay.
It's their document that recommends that.
All right.
Center front, go ahead.
Hi, Steve Feldman, CBS Interactive, not a lawyer. But I do have to talk to lawyers whenever I want to buy anything that has a contract associated with it. And that in itself is a process. So even though, as you pointed out, we already signed the RSA years ago, it took 10, 11 months to convince our lawyers to sign it again when we had to update it for some reason a while back. We can, in fact, get an indemnification clause signed if we can convince them that it's worth it, but that's hard to do. We'd have to do that all again if we wanted to sign the RPA as it is. For me, in my particular role, it doesn't make a whole lot of sense to go through that work. It would be easy if it could be covered as part of the RSA. It would be easy if there were another way to accomplish it. But as it is, it's not worth the effort for me, which is why I'm not going to adopt it at this point.
Understood. Okay, well, I'm going to close the queues, so keep going.
Kevin Bloomberg, The Wire. On the light side, I did stay at a Holiday Inn Express last night. On the serious side, ARIN isn't the dominant RPKI player in the regions. As such, we are not in a position to make much dictation when it comes to things if we want to see successful deployment of RPKI. There's a lot of personalities at play here. A wraparound click-through should not be an issue, but because we are the non-dominant player in this region, it's, in some respects, this is personality as to why this is not being used. There was just a post to the mailing list. 2 RPKI players that turned up in another region specifically excluded ARIN. Not because they consciously wanted to, because they're making a point. That's what's going on right now, and it is devolving. The most important thing, John, as far as I'm concerned, is this needs to be expedient, and another year is not expedient. So that's the one thing I did take from a lot of this stuff, and I am not trying to get into the specifics of it because it is way beyond my pay grade. But it took a year to do your original report, and you said it's going to take probably another year to get somewhere. And this is going to devolve between the NANOG in October and now. This has already devolved significantly, and another 6 months or 12 months, it's going to continue to devolve. So all I can suggest to yourself and the board is expedience, expedience, expedience.
So I want to respond, just to be clear. We're moving very quickly. We really are, but recognize that the board has to make this call. This is truly that level decision, and they're entitled to have good analysis. Some of these options, we literally, as we said, we just got these reports a few months ago. Some of these options, like a separate affiliate, insurance, require detailed work in order to be able to give the board the answer or the choices and the risks involved in each. And you don't want to make a half decision while one of those is pending, because one of those options could significantly influence the balance of the scales on how you go. So I don't know how long it's going to take. We're aggressively doing it, but I do not recommend the board making decisions with incomplete information. And so it's just a question of us doing the work as expeditiously as possible. I want to bring up one more point, just to be clear. So we have more parties doing route announcements now, more networks doing it. We are still growing. We actually, not in terms of percentage, but in terms of count, in terms of objects and networks covered, are actually moving up slowly but surely. We're now number 3, we used to be number 5, and it's not a percentage issue, but then we're also a very large area. When you say we're not the dominant player, we see a lot of RPKI activity going on in America, in this Canada, US, and the Caribbean. We see a huge amount of activity. The slope doesn't necessarily match other places, but that doesn't mean it's not growing even right now.
No, the issue is that other regions are using what's going on and turning off ARIN, or not turning it on in the first place, which is not going on elsewhere. And we are not, by numbers, the number one,
Sure,
right?
sure.
I am not asking you to do a poor job. I'm saying throw whatever you can at this, because it's going to get worse fast.
Okay,
Thank you.
Go ahead. I actually closed the queues earlier, so everyone after the remote monitor, I'm not sure what you're doing here. We're well beyond time. So oh, right, I said everyone after the remote monitor. Okay, so go ahead, Owen.
Owen DeLong, ARIN AC. You talked about announcing an outage ahead of time being a recipe for the hackers. Couldn't you have an authenticated list of people that want to be notified that have somehow authenticated themselves as being relying parties and announce only to that list, thus mostly avoiding notifying the hackers?
Right. There are options, and we need to tease these out, but that's a great idea. Go ahead, Andrew.
Remote comment from Jason Schiller, Google ASOAC. Thank you for this presentation and your continued work to reduce the gap and barriers to usage of RPKI in the ARIN region as compared to the other 4. Please continue this work and increase my fees if that is what is needed to make appropriate progress. Can we please get this presentation and updates of this progress at the next NANOG meeting?
Next NANOG meeting, understood. If the program committee honors me, sure. Yes, last speaker.
My apologies, because even writing down, I forgot something. Joe Provo, Google, ARIN AC, speaking for myself.
Yeah.
In addition to fees, since there were concerns about insurance, and my apologies if it was in the report. Have we explored, has the board explored discussions with the other IRRs for increasing the Joint Stability Fund to cover this sort of eventuality?
Right. So there is, well, the Joint Stability Fund is a very small number compared to our organization. If we see a damage that's order of magnitude a year or two worth of our fees, order of magnitude our reserves, there's insufficient water and there will never be enough to sustain us. So unfortunately, we would take down the Joint Stability Fund and the other RIRs in the process. That's really the issue we face, is that the problem is that in a litigation like this, if you face that from several hundred parties, you actually, the uncertainty of the outcome combined with the length and the process to get clear encourages settlement, and even that could be debilitating to our organization. So I guess the work that we're most likely to end up, if we do anything with the other RIRs on this jointly, would be look at, for example, maybe there's joint publication possibilities, and that's not unheard of. I'm not sure we'd incur the risk and then share the risk with our RIR brethren. Seems to be rather cruel in a number of ways. Microphones are closed. Anything from remote? No? And Chris, you only had only one question for you, so if you want to say something in closing.
Only that we'll be around at lunch. If there's other engagement you'd like to do, we'd be open to it, because this is a process and a dialogue. And thank you for allowing us the forum to engage the community.
At this point, we have a couple of presentations before break, but I am not cruel, so we are going to take the scheduled break at this time. And so folks go outside, and we're resuming here promptly at 11 o'clock. So take your break, and I'll see you back here at 11 a.m.